The Beneficial Ownership Information, or BOI report, is a federal requirement designed to increase transparency by identifying the individuals who own, control, or benefit from a company. Its primary goal is to combat money laundering, terrorism financing, and tax evasion by exposing the true owners of legal entities. Starting January 1, 2024, most small businesses, both new and existing, must submit a BOI report to the U.S. Department of Treasury's Financial Crimes Enforcement Network, also known as FinCEN. BOI and the IRS. The BOI report aligns with the IRS's efforts to enhance financial transparency and combat financial crimes. Under the Corporate Transparency Act, or CTA, BOI reports are submitted to FinCEN, with the IRS being one of the authorized entities that can access this information. How the IRS uses BOI information. The IRS may use BOI information to investigate tax evasion. The IRS can identify the true owners of businesses under investigation for hiding ownership or income, ensure compliance and conduct audits. BOI data helps verify that businesses and individuals comply with tax laws by revealing who controls companies and receives profits. Support anti-money laundering efforts. The IRS involved in AML activities may use BOI data to track suspicious financial transactions. Although the IRS has access to BOI information, this data is not made public and is only used for legal and regulatory purposes, such as enforcing tax compliance and investigating financial crimes. Filing deadlines. Under the Corporate Transparency Act, entities formed before January 1, 2024 must submit their initial report by January 1, 2025. Entities formed or registered on or after January 1, 2024 must file their BOI reports within 90 days of formation or registration. Entities formed after January 1, 2025 must file their BOI report within 30 days of formation. Updates to BOI information. Although the BOI report is typically submitted once, businesses must submit an updated report within 30 days if any changes occur. An updated report is not just a partial update reflecting only the new or changed information since the initial submission. Instead, it is a complete report, including both unchanged and updated information. Certain changes trigger the need for this update under the Corporate Transparency Act, CTA, and similar state regulations. Key examples include 1. Change in beneficial owners. If someone who owns or controls at least 25% of the company's equity or voting rights changes, whether through a sale, transfer of shares, or merger, an update is required. 2. Change in control. If an individual gains significant control of the company without owning 25%, such as through voting agreements or management control, an update must be made. 3. Changes to existing owners' information. Any modifications to the personal details of current beneficial owners, such as a legal name change, new address, or updated identification, for example, passport or driver's license, would require an updated report. 4. Change in company structure. If the company undergoes restructuring, such as converting from an LLC to a corporation, and this affects ownership or control, an update is necessary. 5. Change in company address. Businesses must file this updated information within 30 days of the change to remain compliant and avoid penalties. Who must file a BOI report? BOI reporting is required for corporations, limited liability companies, limited partnerships, and other similar entities registered with the Corporation Commission. Exemptions include publicly traded companies, large regulated entities like banks, government bodies, nonprofits, and inactive entities that have filed termination documents. Most small and medium-sized businesses are required to file. What is a beneficial owner? A beneficial owner is defined as an individual who owns or controls at least 25% of a company's equity, exercises significant control over the company's operations or decisions, or receives significant economic benefits from the company. Under the BOI, Beneficial Ownership Information Reporting Requirements, Significant control refers to the ability of an individual to influence or direct key decisions within a company, even if that individual does not own 25% or more of the company's equity. A person with significant control might have authority over the company's financial policies, business strategy, or operational decisions. Key indicators of significant control include holding a senior management position, for example, CEO, CFO, or other executive roles. Control through voting rights or agreements, allowing the individual to dictate key corporate decisions. Directing or influencing the board of directors or similar governance structures without owning a large percentage of equity. Even without owning substantial shares, such an individual must still be reported under the BOI regulations if their control impacts the company's decisions or operations. This definition includes indirect control through proxies, trustees, or intermediaries. Required documents for BOI filing: Company Identification Information 1. Legal name of the company, trade or DBA names, if applicable. 1. Business address. 2. Jurisdiction of formation, state or country where the company is incorporated. 3. Taxpayer Identification Number, TIN, Employer Identification Number, EIN, or other government-issued identifiers. Beneficial owner information. For each beneficial owner, that is, individuals who directly or indirectly own or control at least 25% of the company or have significant control, the following information is required. 1. Full legal name. 2. Date of birth. 3. Residential address. 4. Identifying numbers, for example, U.S. passport number, driver's license number, or foreign ID number. Image of the identification document, for example, a copy of the driver's license or passport. Who has access to BOI information? BOI information is kept confidential and only accessible to the IRS, federal, state, local, and tribal law enforcement agencies investigating financial crimes, financial institutions for AML and Know Your Customer compliance, and certain regulatory agencies. BOI data is not made public and is only used to combat illicit activities. Penalties for failing to file a BOI report or submitting false information can lead to 1. Civil penalties. A fine of $500 per day for each day the violation continues, starting from the due date. 2. Criminal penalties. Willful violations may result in fines and imprisonment for up to 2 years. These penalties apply to businesses that fail to file, provide false information, or fail to update their BOI reports on time. Even if you were unaware of the BOI reporting requirement, you may still face penalties, as the responsibility to comply rests with the business owner or entity. Businesses are expected to stay informed about regulatory changes through advisors, such as accountants or attorneys. BOI reporting is essential for identifying individuals who hold significant control or ownership of companies. Non-compliance can result in severe civil and criminal penalties. Beneficial owners are those who own 25% or more of a company or exercise significant control over it. Filing requires personal identifying information, and access is limited to government agencies and financial institutions to ensure confidentiality. Hiring a professional to file the BOI report offers several key advantages. 1. Avoid errors and penalties. Professionals such as accountants or attorneys are experienced with complex reporting requirements. Filing mistakes or omissions can lead to significant penalties, up to $500 per day, or criminal penalties for willful violations. Professionals help avoid such risks. 2. Handling complex ownership structures. For businesses with complicated ownership arrangements like multiple owners, foreign entities, or trusts, professionals can ensure the correct individuals are identified and reported. 3. Staying up to date with regulations. BOI reporting rules may evolve, and professionals are well versed in these changes. They can offer ongoing advice and ensure compliance as your business structure evolves. 4. Saving time and effort. The filing process can be time-consuming for businesses unfamiliar with the requirements. Hiring a professional allows you to focus on running your business while ensuring the filing is completed efficiently. 5. Ongoing compliance support. Should there be changes in beneficial ownership or business details, a professional can help update the BOI report in a timely manner. 6. Mitigating audit risks. Properly filing the BOI report minimizes the risk of triggering IRS audits or law enforcement scrutiny. Professionals ensure the report aligns with other filings, reducing red flags. 7. Peace of mind. Knowing your BOI report is in the hands of an expert provides peace of mind, especially if you're unfamiliar with financial reporting. In summary, hiring a professional can help ensure compliance and accuracy while saving time and reducing the risk of costly penalties. The Beneficial Ownership Information (BOI) reporting requirements in the U.S. were established under the Corporate Transparency Act (CTA), which was enacted on January 1, 2021 as part of the Anti-Money Laundering Act of 2020. The U.S. Financial Crimes Enforcement Network, FinCEN, the agency responsible for collecting BOI data, issued final regulations for these reporting requirements in September 2022, providing specific guidelines for compliance. So while the CTA was passed in 2021, the actual BOI reporting obligations begin in 2024. Alabama Federal Court recently ruled that the CTA is unconstitutional in a case involving the National Small Business Association, NSBA. However, the ruling is narrow and applies only to the plaintiffs in the lawsuit. FinCEN has made it clear that the decision does not apply to other businesses in Alabama or elsewhere. As a result, other Alabama-based companies are still required to comply with the CTA's reporting requirements. The federal government is expected to appeal the ruling, meaning that the CTA may still be enforced in Alabama, depending on the outcome of the appeals process. New York has been working on its own beneficial ownership legislation, which mirrors some aspects of the Federal Corporate Transparency Act. The New York legislation aims to create a public database of beneficial owners for LLCs formed or qualified to do business in the state. This database would include the names of individuals who ultimately control or have substantial ownership of these entities. The law, if enacted, would apply to LLCs and similar entities registered in New York. One significant difference from the federal CTA is that the New York database would be public, providing broader transparency, whereas the federal BOI data collected by FinCEN is private and only accessible to government agencies. As of late 2023, the bill was awaiting a decision from New York Governor Kathy Hochul with a deadline of December 31st for action. If passed, this law could set a precedent for other states to adopt similar measures, furthering transparency and efforts to combat illicit financial activities. California has been considering its own version of beneficial ownership legislation, modeled after the Federal Corporate Transparency Act, CTA. This state-level proposal, though still in the review stages as of late 2023, seeks to introduce reporting requirements for companies, particularly LLCs, formed or registered in California. The proposed legislation would establish a beneficial ownership reporting system that mandates companies to disclose their true owners. Like New York's initiative, California's law would aim to increase transparency to prevent the use of shell companies for illicit purposes, such as money laundering or tax evasion. The California bill is still under review in committee, so its specific provisions and implementation timeline are yet to be finalized. This push in California aligns with broader efforts across the U.S. to increase corporate transparency at both state and federal levels, aiming to close loopholes used by bad actors hiding behind anonymous companies.